I'm Dean Reuter, Senior Vice President and General Counsel of the Federalist Society. I'm very pleased to welcome you to today's program, sponsored by the Capitol Hill chapter and put together by my colleague, Savannah Greisinger, and her team, and supported by our digital team and promotional team and everyone else. So thanks to all of them for making this event possible. Thanks also to all of you for taking time out of your schedule today to join us. We're going to proceed in a typical format for Federalist Society, a fireside chat where I ask our guest, Paul Clement, a handful of questions. We'll do that for about 40 or 45 minutes or so, at the end of which we'll turn to the audience for questions. I don't know if we have a microphone for audience questions. We do. We do. So raise your hand, you'll get called on, and the microphone will come to you. Wait for the microphone to ask your question because we do have video of this, and we'll want to make sure we get your question on the record, as it were. So we're very pleased to welcome Paul Clement with us today. He's known to, I would venture, everyone in this room. What you might not know about him is he was the 43rd Solicitor General of the United States after having been the principal Solicitor General, principal deputy, and the acting Solicitor General. He has also served in the legislative branch as Chief Counsel of Senate Judiciary. He, in the judicial branch, served as a clerk to Judges Silberman and Justice Scalia. He's been at, as we'll talk about in a minute, any number of law firms during his career. And he's argued over 100 cases in the U.S. Supreme Court, widely recognized to be the leading advocate in that bench, in that court. So we're very pleased to welcome you here today, Paul. Thank you for being with us.
No, my pleasure. It's great to be with you, Dean.
Good. So the first question I have relates to what I just mentioned, and that is your tenure at law firms, in and out of law firms. Sometimes you leave a law firm to go into government service. There have been other moments when you've left law firms for different reasons, and I wondered if you could talk about that for a few minutes.
Sure. No, I'd be happy to, Dean. I think what you're alluding to is, the basic fact that I just can't keep a job.
Yeah. I didn't want to put it that way.
No, but it's really, it cuts to the heart of the matter. And as you say, I mean, in some of my sort of career moves have been sort of the more typical Washington, D.C. Kind of fodder of like leaving a big law firm to go into government service. And then, in my case, after I served in the Bush administration, I went back to my old law firm, King & Spalding. And again, that's a very sort of tried and true kind of path in Washington. And I think one of the things that kind of distinguishes the practice of law in Washington is the ability to move in and out of government. So that piece of it, I think, is pretty normal. What I think is more kind of distinctly, my issue is the fact that I've also moved from big law practice to kind of small boutique practice, and then back again, and then back again. And each time I've left sort of big law, it's been not because of performance reviews. Mm-hmm. It has been because I took on a representation that over time, in one case or almost immediately in the other case, proved unpopular in particular in circles. And so I was kind of confronted with the proposition from my law firms that you need to drop that representation, or otherwise you're going to have to leave the firm. And in both instances, I made the judgment to stick with my client and practice law elsewhere. In both instances, I think that was not just the right decision, but really the only sort of proper decision for a lawyer under all the circumstances, because I think once you take on a representation, you do have an obligation to see it through, unless conflict develops, or the legal guild is very good at taking care of the legal guild. So there's always an escape hatch if your client does something really unforgivable, like refuse to pay their bills. But absent those kind of extraordinary circumstances, the legal ethics rules are pretty clear that you should stick it out. And so in both instances, that's sort of the judgment that I've made. I will say what has struck me, though, about the difference is the first time I left, it was over the Defense of Marriage Act. And I had been retained by the House of Representatives to defend the constitutionality of the Act of Congress. And I will say that's something that felt sort of very natural to me because I just spent 7+ years in the Solicitor General's office, where what you do is defend the constitutionalities of Act of Congress. And that whole case was precipitated by the Justice Department kind of deviating from the normal order and declining to defend that law, even though the law was passed by wide bipartisan majorities, and the Justice Department had, for the most part, been pretty successful in defending it in the lower courts. But nonetheless, they made a judgment to refuse to defend the law further. I got involved, and and my law firm made a decision almost immediately once there was kind of a little public pressure to abandon the representation. And I guess, on that one, I certainly think my former law firm did the wrong thing, but you could imagine that sort of same-sex marriage is one of those issues that you could say, well, that's just kind of so divisive. And you also could say, I took on that representation knowing full well that given the current composition of the court at the time, we were probably unlikely to end up on the winning side of that case, just if you were going to sort of count noses as opposed to just go by sort of precedent. But the second time I left, it really struck me as an even more bizarre set of circumstances. Because the precipitating issue there was our representation of the NRA and other parties trying to vindicate their Second Amendment rights, and that's not like an issue where, it's become, I suppose, divisive from the perspective of big law, but it's right there in the Constitution that that's one of your essentially inalienable constitutional rights. And then the thing that really struck me as bizarre about it is we had just prevailed 6-3 in the Supreme Court. And so the prospect that a law firm was basically going to say, well, it's all well and good that in a Section 1983 action, you just vindicated the constitutional rights of 2 citizens of the state of New York, and again, did so successfully with a vote or two to spare. On the margin, but nonetheless, you have to drop that representation immediately or leave the firm. To me, that just is almost just unthinkable that a law firm would sort of make that judgment. Because what it says is not just about sort of the profession, but it also projects sort of a view of the Supreme Court, which has just vindicated this right, that you just think, that just shouldn't be, that just shouldn't happen. It's almost inconceivable, but then again, it happened.
That's right.
Yeah.
And it's not as if it's on the heels of a case that you lost badly and suffered sanctions or something like that.
Right. No, exactly. And then again, to me, it's highly relevant that it's a 1983 action. This is one of our greatest statutes. Is this statute passed in the Reconstruction era to vindicate?
Depends on what it's used for, though.
Well, it depends on which constitutional right that you're vindicating. That's exactly right. But I've always been a big proponent of, and you see this happen in litigation, where you get sort of people who are on the left and the right, but are both in the business of vindicating civil rights, but different civil rights, to kind of find common ground and agree that 1983 should be interpreted in certain ways. There should be attorney's fees available under Section 1988 for vindicating sort of constitutional rights. I don't know, I just had this crazy notion that one of the kind of noblest things you could do as a lawyer is to successfully bring a 1983 action and litigate it successfully all the way to the Supreme Court and vindicate sort of people's constitutional rights. So the idea that a successful sort of 1983 action in the Supreme Court is what sort of precipitated the need to pack my bags was pretty shocking to me, and certainly a very good reason to pack my bags.
So I wonder if we can turn to just the topic of freedom of thought in law firms. And as we discuss that, I'm curious about a defense of the law firm in this case, the business defense, that this is bad for our business to continue to represent client A or client B. How should individual lawyers and how should law firms balance the ethical requirements versus the notion that they're professionals versus the notion that they're businessmen and women, they're running a business, and continuing to represent a client or failing to represent a client could have business repercussions for the entire firm?
Yeah, and I think, like, in some levels, I think the answer to this is pretty straightforward, because, if somebody said to the managing partner of a law firm, we've run the numbers, and it's going to add to our bottom line if we completely disregard the attorney-client privilege and just disclose this information. It's client information, it's definitely privileged, but we'll be heroes in certain circles, and we've pretty much been told that we'll get a whole swath of business if we take this unethical course. I think it would be unthinkable that any law firm would follow that path. And I think what it shows is that, to do this right, you have to be a professional first and a business person second. And that doesn't mean that you can't make a fine living practicing law, and it doesn't mean that within the bounds of kind of the ethical limits that you can't make sort of prudent business decisions. But it does mean, at the end of the day, these are professional organizations that are bound by professional responsibilities. The law firms would be the first to tell you that if it was convenient for them to rely on sort of, privilege or the attorney-client relationship, and yet, that is the justification that some would use to part with an unpopular client. And it may be exactly what sort of explains the decision here. I tend to think that it's incredibly short-sighted, because I think that, not to use sort of a hokey term, but, anytime, if it really is the case that some clients would, give a law firm a hard time about successfully defending an unpopular client, I think that's got to be considered a teaching moment.
Yeah.
Because, it is in the nature of practicing law that typically clients who have no legal problems and are not unpopular with anyone don't need your legal services. So even the clients that are complaining, presumably they're clients for a reason. And even if today they're not sort of facing down some lawsuit based on the idea that they've done something horrible to somebody, they're eventually going to be in that position. And so the opportunity to say, I know you may think that, but in the long run, you're going to love the fact that we're here to represent you, whether you're popular or unpopular. We're going to stick by our clients, and oh, by the way, we're going to win. I think that's a pretty easy message to deliver.
And can you talk for a minute? You've used the term divisiveness a couple of times, and in my training a few decades ago, it was the adversarial system, and that's the way the system's designed. It is by definition divisive, and only, to some extent, I suppose, only the most controversial or divisive or difficult issues find themselves in the Supreme Court. It's a bit stunning to me that a firm would shrink away from things that are divisive. And maybe as you talk about that, if you could say a few words about if there's a difference between an unpopular client and an unpopular matter, a difference between the House of Representatives, the People's House, and DOMA versus the NRA and the Second Amendment. How do those things factor into all of this?
Yeah, so I think you're right. And I guess you can sort of think about, in a world where maybe there's like just one or two issues that are perceived to be kind of so divisive that they're off limits, as long as there are sort of public interest groups or others that are maybe willing to vindicate those issues, maybe the system can sort of operate in that world. But as the scope for what's divisive starts to eat more and more of the adversarial process, as you say, then it really doesn't become terribly sustainable. The one thing that I'll say that sort of partially explains this, there's really two things that are going on. one, not to sugarcoat it, there aren't that many issues that if you take the liberal side are too divisive for people to take at big law firms. So if you look at the amicus briefs that are filed in like abortion cases, you will see very quickly that this is not something where like, oh, well, this is sort of like a bipartisan thing where everybody's decided there's a handful of issues that are too, hot to handle. So, am law 100 firms will stay out of those cases, and you'll just have public interest groups on both sides. I mean, au contraire. In a case like the Dobbs case, most of the major law firms are there. They're just all on one side of the case. So that's a huge part of what explains the phenomenon that's going on right now in big law. The other thing, which is subtler but is also part of the problem, is that some of the sort of biggest, most profitable law firms have really come to be dominated by, in the management level, by their transactional practices. And transactional lawyers are a little different from litigators. And because at the end of the big transaction, both sides perceive, at least in the very short run, that they've made a favorable transaction. Both sides, either separately or together, are going to have their little signing dinner where everybody thinks that there's really no bad guys in this. And so I think in that sense, the transactional lawyers just don't have the same innate commitment to the sort of adversarial process as litigators do. And in a world where most of the big law firms used to be run, either entirely or at least in fair measure by the litigators, I think there was a little bit more of this commitment to, well, of course we represent unpopular clients. I mean, popular clients don't get sued. The business interests and the ethical interests kind of aligned. But I do think with the more that the transactional people are running the show, the less that kind of course we're lawyers, and of course we're going to represent unpopular clients. It's just not in the sort of the bloodstream in the same way.
And then you can't rely on what the transactional lawyer should feel about the duty to a client. I mean, even if they're not in complete opposition in a transaction, they're on opposite sides of a table, and they have a duty to represent that client. That can't carry the day in big law anymore when it comes to divisive matters or unpopular clients, it sounds like, at least in big law.
I think that's right, but I honestly think you could probably find some big law firms that would be happy to do the NRA's transactional business, because it's just paper and a deal. It's not the same like getting in there and really saying, no, somebody has a constitutional right to have a firearm for self-defense purposes in the state of New York. I mean, that is, an alarming prospect for certain people in New York. So it's just, I think it is kind of controversial in a different way.
Well, and I guess the visibility to the public of those two different styles of representation is different.
Yeah.
So.
No, in an odd way, I do think, part of it is just, as you can probably tell just from this conversation, I'm a difficult person to get along with.
I've always found that to be true.
So I'm sure that's part of why this has happened to me twice. But I actually don't think it's coincidental that my practice is a Supreme Court practice, because if you're just doing a case in district court somewhere, even if it's a little bit unpopular, it's not going to be in the headlines. It's not going to help set the new sort of nationwide rule. But if you're up there in the Supreme Court defending the Defense of Marriage Act or vindicating Second Amendment rights, it's hard to do that quietly.
So just an off-the-cuff practice tip for you: if you were more agreeable, you might have a better success rate in the court.
That's right. That's right. Should have been 3-6. It wouldn't have been a problem. I would have vindicated nothing.
I want to turn to the duty, an attorney's duty to represent an unpopular client, and where does that begin and end? And talk about, if you would, the difference between retaining a client in the first instance versus keeping a client in an ongoing representation. And you mentioned there are times when you can end a representation. When I was in school, early in practicing, the key words to say to a judge is you had a disagreement with your client, which meant they're not paying us.
Right. So, yeah. No. Exactly.
And then you could get out virtually any relationship, which, I mean, now that I say that out loud, it makes me wonder about the business versus the ethics. If you're not being paid, you can walk away from a representation. you have much more latitude there. But back to that original question about retaining somebody in the first instance or keeping somebody.
Yeah, and I do think they are different questions. And, I did, when I was leaving King and Spalding, I did come across this great quote from Judge Bell, Griffin Bell, former Attorney General, but also former King and Spalding partner. So it was kind of delightful that I came across that in time to include it in my resignation letter. But he really drew this sharply, the distinction sharply between, at the beginning, there are circumstances where as an ethical matter, and we can talk about them, as a member of the bar, there are certain representations that, essentially if nobody else is in a position to represent somebody or the court asks you to represent you, you're sort of ethically bound to take on that representation. But for the most part, a lawyer has a fair amount of discretion in what matters they take on in the first instance. But once you take on a matter, then the calculus changes, and you really do have that, the attorney-client relationship forms, and then you have, very distinct and special responsibilities, not unlimited, but very special and distinct responsibilities to stick with that client. And part of it is just, I think, a practical notion that if you abandon a client, particularly for the reason that there was public pressure brought to bear because the client was perceived to be unpopular, and if you abandon the representation at that point, you're really disadvantaging your client, because at that point it's going to become that much more difficult for any other lawyer to take on the representation, because they've already seen what will happen if they do, is that they will be subject, and their firm will be subject to a public pressure campaign and the like. And so, I do think the rules draw that distinction very clearly, and I think for good reason.
Yeah. Yep. So before we leave this topic and turn to the next, I want to ask you a question about boutique versus big law. And we've seen a lot of boutique law firms start, a lot of them, and I like citing your observation about the Dobbs case, where in terms of AMLA 100, I think there were 43 briefs and 42 of them were on one side.
Yeah.
Is the creation of boutique law firms people's flight, conservative and libertarian flight from big law to create boutique law firms, does that exacerbate the big law problem? Is that a, and I'm not talking about an individual experience, but as a phenomenon, is that a good thing for the practice of law? Is that a bad thing? It's like us versus them. How do you sort that out, or have you given much thought to that?
So, I think it's, kind of a classic second best, sort of option. I mean, for conservative and libertarian lawyers, I do think that, boutique practice holds a lot of promise and is a, something that, I'm voting with my feet right now and doing, but would also kind of recommend to others as maybe, the single best way to practice law in 2024. But I do think that tends to exacerbate the problem, because then there are even less conservatives at big law firms. And the ones who are there are the ones who have sort of opted not to, leave. I mean, there's, a great economics book by, I think it was Hirschman, about exit, voice and loyalty, but kind of gets it, for all institutions, if it's great that you have the ability to exit, but if all the conservatives exit, it does tend to kind of make the problems at the institutions that remain even worse. So I do think there's some truth to that. And then I do think it's a problem for the practice of law generally, because boutiques are a great option for appellate practice, maybe for certain kinds of specialized administrative law practice. If you wanted to have more of a legislative practice, I think you could also do that pretty effectively at a boutique. Mm-hmm. But there's certain kinds of cases where you need to throw some bodies at the representation. You need the resources of a larger law firm, and I think that's particularly true in certain kinds of trial practice, where you just sort of, it's pretty hard to put together a full-blown, if you're going to do one of these redistricting cases, for example, and you need bodies to litigate a case and go do sort of discovery on all of the state government's files to prove this, that, or the other thing. It's pretty hard to do that at a boutique, and it's much easier to do it at a big law firm. Mm-hmm. And if all the big law firms are left of center, And so when it comes to a sort of challenge a Republican redistricting plan from the left, you have, big law, throwing 30 or 40 bodies at it to, vindicate the rights of democracy. And if the roles are flipped, you just don't have any big law firms that are willing to do it. Or maybe Jones Day is still willing to do it, but there's only so many cases one law firm can do. It's a tough dynamic, and it skews the system in ways that, getting back to your observation about the adversary system, our whole legal system is kind of presupposes relatively equal resources on both sides of the V.
Right. So getting back to representing individual clients, I want to turn to the Senate confirmation process, at least briefly. Is it fair for the Senate to judge nominees to the judiciary or to the executive branch or any confirmation process by the clients they select? And what do you make of the argument? It's like somebody else could have done that. You didn't have to be the one person to represent that client.
Yeah, so, my thought on this, and this goes back to, being a staffer on the Senate Judiciary Committee for Senator Ashcroft, who is, certainly on occasion willing to raise a representation that a judicial candidate had made. I think there is a role for that being raised as an issue. I've always kind of drawn a distinction in my own mind between sort of the pro bono representations and the non-pro bono representations. I mean, getting back to what we were discussing, you do have optionality in taking on cases. Mm-hmm. And so, and particularly in pro bono cases, if a judicial candidate is taking on pro bono cases and they all are on sort of, one side or the other, that seems like a perfectly sort of fair game thing to raise. I think on the other hand, raising it is one thing, and then how you respond to it. And I do think, if somebody can say, particularly with respect to their paid cases, yeah, I worked on those cases. That was part of being a partner at so-and-so law firm. And, I don't think that really provides much of a basis to vote against a nominee. But I do think the pro bono cases are probably different. Mm-hmm. Again, they're a fair sort of topic for discussion. Again, I think it's in the noblest traditions of the bar if the answer is, yeah, I took that kind of controversial pro bono case on precisely because, the court asked me, or I thought it was very important. I didn't think that person could get kind of qualified representation if I didn't take it. I mean, those are all, to me, pretty compelling answers. As you alluded to, if for example, with some of my controversial clients, when I try to say this is the proudest, yeah, it's crazy people like that. When I try to sort of, invoke the proudest traditions of the bar, you do hear, well, but you didn't have to take it. This wasn't some death row sort of, person who couldn't get any other representation. And I just think that's kind of a canard. I mean, first of all, I think representing death row inmates is also in the noblest traditions of the bar. I've done it myself, but in my experience, there are plenty of big law firms that are willing to line up to do that because that's still perceived oddly as being like sort of less divisive than vindicating Second Amendment rights. But at the same time, I think the whole construct that, the only reason that a lawyer can take on an unpopular client is if they're the last lawyer on the planet, or at least the last lawyer on the planet willing to represent that person, is just wrong-headed. And it gets back to my point about, having all the big law firms skew left is not just an annoyance. It's bad for the practice of law. It's bad for the bar. Mm-hmm. Because it's not that you just want people to have representation, you actually want them to have good representation. And frankly, in a perfect world, the best available representation. And to have that, you need something where there's a legal culture that's very open to taking on unpopular clients. And I think, lawyers almost have a little bit of a responsibility to recognize that there's something a little countercultural to that. I mean, the world has become so divisive, and, it's very tempting to sort of say, all right, well, even as like a conservative legal boutique, I'm just going to take conservative clients because they're the ones that don't get a fair shake at the big law firms. I still try to represent some, clients that leave some of my conservative friends scratching their heads, because I think it's important to reinforce the idea that what we're doing as lawyers is something different. We're not just picking political sides. We actually are representing clients and, and taking on sort of distinct responsibilities to them. And, if we feel that we can, particularly well represent somebody across the political aisle, I think it's an affirmative good thing to take on that representation, in part to just reinforce this idea that, what we are on about as lawyers when we're representing a client is something different from kind of the just normal, yeah, of course, I go to the Orioles game with my Republican buddies because I'm a Republican. We're doing something different when we take on a client.
Washington has a team.
I guess sort of.
So the view, I love the view you just expressed. Is that the predominant view in the bar? And I don't mean just litigators. Is that the predominant view among lawyers today? Do you have a sense of that? And relatedly, has the organized bar, whether it's state bars or the ABA or whomever, been clear enough on the duties of lawyers and representing unpopular clients? I remember hearing a lot about it back in the Gitmo representations, less about it more recently.
Yeah, no, in neither time when I left big law to stick with a client, in neither case did I get a congratulatory letter from the American Bar Association. Yeah. And so I do think that the major bar associations themselves sort of skew left, which is why you hear a lot about the basic principles in John Adams when it's representing Gitmo detainees, but you don't hear sort of the same things when it comes to representing conservative clients. I think that's shame on them. Mm-hmm. I guess despite having left 2 law firms and all of that, I'm still dispositionally an optimist, and I still think that most lawyers, if you remind them of it, still sort of get this and feel it. I worry that it's maybe more prevalent in lawyers over 50 than lawyers under 50. Mm-hmm. In the same way that I just sort of worry that the commitment to the First Amendment is becoming a little bit generational. Mm-hmm. When I can find lots of kind of friends of mine who are left-leaning, who agree with me on free speech principles. I think they're all over 50.
Yes, so that's my identical observation, and I'll ask you a question about that if I could. Does that extend to the young lawyers you encounter, either in big law or the ones you're interviewing with, or people coming off clerkships? And is there a left and right divide there? Do people who would identify as conservatives tend to have a greater respect, even if they're young, for free speech and debate and discussion?
So I think the answer is yes. I think we may be in danger of losing even that, though. Mm-hmm. So just to elaborate, I do think as to both sort of First Amendment principles and sort of the principles of the legal profession. Mm-hmm. I do think it's now like everybody over 50 and young conservatives against sort of young progressives. But I feel like it's weakening in the young conservatives, and I think it's in part, I don't entirely blame them because they're going through a sort of experiences where everything seems so divisive, and particularly if they're at sort of relatively elite institutions, things are incredibly divisive, and they seem like they're always in the minority, and so it just naturally breeds a little more of the mentality that this is great in theory, but in practice it sucks. Mm-hmm. So, if we get the levers of power, we're going to be less committed to these kind of cross-cutting principles. But I still think, I still think there's more, even though it's weakening, I still think it's there among sort of young conservatives, and I think the FedSoc lawyer chapters and student chapters does a pretty good job of helping to continue to foster that, but I don't feel like the commitment, even among the young conservatives, is as deep-seated as it was when I was sort of going through those institutions.
Yeah, interesting. So we're going to turn to questions from the audience in a couple minutes. So I've been writing down my own questions and making them up as we go along. But I want to change topics if I could, and that is to the just general topic of the state of the judiciary, the relationship between practitioners and judges, attacks on the judiciary, and I guess what I would describe as attacks on the judiciary and the implications of that. And the first question relates to and I don't even know if this is still happening, but protests at the homes of justices of the Supreme Court for one reason or another.
Yeah, and I'm not positive whether that's still ongoing. I think it unfortunately may be. To me, that's just like one sort of manifestation that it does seem like the level of the sort of criticism of the court, the tenor of the criticism of the court is different right now than it has been in any time that I've been sort of practicing law. And I think this is itself kind of a tricky issue in the sense that there were times when the ABA and others on the left were sort of when the court was kind of deciding cases more to their liking, they were kind of advancing the proposition that it was kind of wrong to criticize the court at all or to criticize judicial decisions. And that seems wrong-headed to me. I mean, judicial decisions seem like a perfectly fair, opportunity for criticism and the quality of the opinions, the faithfulness to the constitutional text or the statutory text. All of that seems entirely fair game, and an effort to sort of tamp that down on the theory that it's, institutional legitimacy, judicial independence, that seems wrong to me. On the other hand, sort of, criticism of the court that goes to the core of its legitimacy and whether the decisions are even legitimate, not that they're not subject to criticism, but that the whole institution is illegitimate. And I think much of the criticism, more recent criticism, has kind of taken that form. That seems to me to be pernicious and a real kind of threat to the health of the system. And I think there's a subtle difference between the two. I wish it were just more black and white, because then it'd just be easier to call people out when they kind of cross that absolutely clear line. But I do think, it's one thing to say that's a poorly reasoned decision. That should, be overturned at the first possible instance, and to say that the court that issued that decision is basically illegitimate, and we don't even owe fealty to the rule of law that emerged from it because the whole institution is illegitimate. That just strikes me as a pretty direct threat to our governmental system.
Yeah, I agree. And I don't know if we discussed this in our pre-call, but do you have any insights into the origin of this phenomenon? Is it, I think it's certainly, well, and I'll ask you as well about the organized bar's response to this. I think there's been silence in response to this, unfortunate, which sort of gives a permission slip in some sense. And I think media has been unhelpful in this. They tend to cover the spectacular protests. You have senators on the steps of Congress making statements. What are your thoughts about the origins of this and maybe how to get back to a state of normalcy?
Yeah, I mean, I think that, obviously I think that a big part of the kind of origin for this new wave is just you have decisions that are coming out in a different way, and so kind of criticism of the court takes on sort of a different political valence. And I do think the reaction of the organized bar is a big sort of part of the problem, because, like I said, I mean, I remember going to a couple of these symposiums that were put together by the organized bar to defend the Rehnquist court and largely Justice Kennedy and Justice O'Connor from sort of criticism that some of their decisions weren't faithful to the Constitution, or to sort of protect some district court that let out some criminal on some imagined technicality. And so when the cases had that valence, the organized bar sort of rallied to the defense of the court in a way that, in my estimation was generally good, but probably overstated, because I think some of them would say, well, just criticizing the decision was problematic. And then here, with this more serious threat, you do really hear crickets. And I think it's a problem in part because the court has very limited resources to defend itself, and kind of requires the organized bar or the bar, disorganized or organized, but it requires the bar to sort of remind people about the nature of judging, the nature of judicial institutions, the nature of our adversarial system. Because I don't really blame, like, if you're a non-lawyer and you just hear the court did X and you don't agree with X, like, if your reaction is, well, then the court sucks. Like, I don't really blame you for having that reaction, and I think it's imperative on the bar to basically say, well, I understand why you feel that way, but here's why you need to take a broader view.
Right.
And here's why you need to understand how kind of our whole adversary system works. And sometimes, sometimes you're going to get a result you don't like because the provision of the Constitution under which it was decided is designedly anti-majoritarian. So if you don't like the result, that means the court's doing its job.
Right.
But like, people aren't going to intuit that. They need kind of lawyers, in their communities who they respect and the like, to kind of explain all that. And if the lawyers are seen as more or less piling on, it's a very bad dynamic.
Yeah, so that I've heard criticism of the Biden administration to the extent that they're less careful about what is legal. They're happy to propose and pass things or sign things, maybe even knowing, and I think in one case, announcing that this would likely be overturned by the court, and in disregard of that, proceeding anyhow, in order to get a regime installed that business has to react to and the regulated community has to react to, even though it's eventually overturned by the courts. Where do you stand on all of that? Are you hearing this? Do you think that's correct? Is there something unique about the Biden administration versus previous administrations in that sense?
I mean, I do sort of, that's my experience as a litigator. I mean, I've been in private practice long enough now that I was hired to challenge some Obama-era rules, and I've been hired to challenge some Biden administration rules. And I felt like the Obama administration, the policies they were doing were progressive, but the people involved, like, still cared about winning in the courts. And if you made an argument to them, even in a pre-promulgation context, and could point out that if you do X, it'll get struck down. If you do Y, we don't really like Y either, but Y is going to be less legally vulnerable. The Obama administration would, in certain instances, not everyone, they weren't always persuaded, but if you could actually persuade them of that, they would trim their sails in order to make the rule legal. I think in the Biden administration, there is like less of that willingness to trim the sails. And I think it gets back to the criticism of the court, because if the courts are sort of taken as being fundamentally legitimate, then it's important for an administration to not get sort of smacked too many times on the wrist for doing things that are unlawful. If the courts are perceived as not even really being fundamentally legitimate, then trying to push the envelope and getting caught a few times isn't really, much of a mark of shame. It just means that you're pushing the envelope for your people. And so the more you criticize the courts as not being sort of fundamentally legitimate, the more you sort of set up a world where, all right, we're going to do this, and maybe it'll get upheld, and that'll be good. Or maybe it'll get struck down by the Fifth Circuit or the Supreme Court, and then we'll just complain about them. And in the meantime, at least, our fellow travelers will be impressed by how hard we're trying, and how we're undeterred by the possibility of getting struck down by those illegitimate courts. Then it just feeds itself in a way that I think is really unhealthy. And to me, no fan of the Obama administration, but in retrospect, I do think there is a material difference between the way they sort of perceived the courts and treated the courts.
So the good old days, the Obama administration. So that, if you have a question, raise your hand, and we're happy to take questions from the audience. I'm sure we must have some. So let's go to here first, and then Dorpenna. So there first, and then here.
Thank you, Paul. Garrett Snedeker with James Wilson Institute and attorney at New Civil Liberties Alliance. Earlier in your remarks, you offered us, I think, a characterization of the circumstances where the most important virtue for you as a lawyer was courage. I mean, you had to assess a situation and take a risk. And I think both instances, from your time at King and Spalding and then at Kirkland, you stuck with your clients. And I think in that way you're an inspiration to all of us young lawyers who we want to stick by our principles, and we know that there are going to be times when doing so won't be easy. But I do think now we are in an unprecedented time where there is a strong and profound chilling effect for any lawyer that wants to be an out-and-out, right-of-center attorney and take on clients that have those interests as well. And I think your courage in the face of the work of Project 65, with Cleta Mitchell, for example, but also perhaps most prominently, and John Eastman, speaks to a situation where I'm very curious if you think that it's going to get worse before it gets better, or if it's going to get worse before it gets even worse.
So, I mean, thanks for the question, Garrett. As I confessed before, I am sort of a dispositional optimist. You know, things are grim enough right now that I just think that, you know, being a pessimist is both too easy and also just would, you know, make life just like, you know, pretty depressing. So I'm going to say that, you know, things will get better. I do think, you know, over the long term, and this is where, you know, I have been in D.C. at this point a fair number of years, and I've seen kind of administrations come and administrations go. I've kind of come to believe that, you know, most sort of bad things can't be fixed until sort of both sides have experienced them in ways, and you know, and I kind of feel like, you know, we're in a situation where, as bad as it is, you know, over time, I'm hopeful that it will get better. I think there are signs that, you know, in some of the stuff that's going on college campuses right now, it just seems like, you know, the envelope is being pushed so far by some people, and in ways that I think have, you know, sort of caught both some people on the left and a lot of people in the middle. It's like, you're kidding, like, you know, and so I'm hopeful that, you know, this is going to sort of cause things to sort of, you know, veer back a little bit. You know, I don't think in the long run it's at all healthy for our legal system to basically either have, you know, all of big law be on the left, or, you know, for big law, like everything else, to be like, you know, because I think there's probably a market opportunity to form a couple of like big law Republican shops. And, you know, I was even approached by somebody on the idea that, you know, that's what we should do. And part of the reason that I didn't take him up on that is because I actually don't think that that would be great. Maybe it ends up being, and the experience of the next 5 years or 6 years will tell us that we actually need to do that because there's kind of no other good option. But I'm enough of an optimist that I just hope that this will kind of be seen that, you know, there have been some real excesses, and we can't really do this law thing unless we have kind of a joint commitment to the principles of what being a lawyer means. And, like, you know, again, I mean, this is really kind of, it's got to get really bad before it gets better, but I am hoping that what's going on college campuses right now will kind of lead to kind of renewed commitment to the idea that, okay, like, you know, the First Amendment is actually pretty important. At the same time, there's something called harassment that's not protected by the First Amendment, and that should also be policed, and maybe we can, you know, get a little bit of a shared, renewed commitment to some of those things.
Do you see a follow-up question on the campus question? Do you see any inconsistencies on people on the right in terms of before or after October 7th? Is everything perfectly consistent along those lines of harassment versus free speech?
Well, I can only speak for myself.
Yeah.
I mean, and, you know, I testified 5 years ago in the House. One of the very few times I've testified because I've spent 2 years as a Senate Judiciary staffer, and it occurred to me that testifying is, you know, more downside than upside. But you know, I thought it was important because there was, you know, a bill about anti-Semitism on college campuses, and part of the point I made in my testimony is that harassment is not protected by the
Right.
First Amendment. And so I'm, I doubt, I would be surprised if everybody has been perfectly consistent about this. But I do think there's a through line that sort of conservatives should feel good about, in that you can be very committed to sort of free speech principles, but also recognize that sort of harassment is different, and that if people are advocating genocide while like looking at somebody in the group that is subject to the genocidal claim, that you don't need additional context, for example.
That could be perceived as harassment.
Yeah,
Yeah.
exactly.
Yeah, yeah. No, that's helpful, I think, that through line. Darpana, right here.
Just on that last point. Darpana Sheth, I'm a head of Fires Litigation Department, so definitely see a lot of that with the First Amendment and this, the new Title IX regs about, what is harassment. And I think we just need to be careful that harassment is defined in a way that's protective of free speech, because we're seeing that not happen. Quick question on the Supreme Court. Arguably, this term is one of the most significant for First Amendment and free speech rights. What are your predictions, I would say, for the net choice cases and how the Supreme Court will define coercion with the NRA case and the Murphy versus Missouri?
Yeah, so, I'm always sort of hesitant to make predictions, and even more so when, I'm counsel of record and at least, the net choice cases. So I'll be modestly responsive by saying that, I think kind of the through line in a lot of these cases is kind of the question of state action. And, I'm a pretty big believer that, almost like in the context of some of the net choice cases and the rest, that like you might not like the social media companies, you might not like their algorithms and what it does to conservative speech, but I still firmly believe that the only thing worse than some of these algorithms is a government-dictated algorithm. And so in that sense, like at the end of the day, the First Amendment issues there seem to me kind of relatively clear. And then I think in these other cases, the issues are maybe a little more murky, but it ultimately, the through line in those cases is still like, where's the state action? Because, the First Amendment, like most of the Constitution, applies only to restrain government action. That's, part of the beauty of our Constitution, that by my count, there's only 2 provisions in the Constitution that restrict private behavior. So it is in that sense protective. It's a charter of liberty against the government. And so that's got to be the principle, the organizing principle in these cases. And I don't know, exactly where that sort of line gets sorted out in some of these cases, but that's got to be the line you're looking for. And you do have to be sort of wary of, I'm presumably, you will not find this controversial, but you have to be wary when the government's trying to say, yeah, there's a speech problem here, and we're here to help you. That's not a great dynamic.
Yes, sir, right there.
Mr. Clement, thank you for your time. Jeremy Burkhardt, I'm an attorney at Holland & Knight. We talked about the generational shift in the views on the First Amendment and kind of the shift in big law, in terms of what cases they're willing to take on. Do you think that any of the problem with this is kind of rooted in the occupational licensing scheme that gives outsized influence to these leftist institutions like law schools and the American Bar Association? And if you do think that's part of the issue, do you have any recommendations for, fixing that?
So, I do think that the fact that, if big law were the only institution that seemed like it was skewed, and, the bar associations and the law schools seemed like they were straight down the middle, you'd be like, well, what's wrong with big law, and how, this should be relatively easy to fix. I do think that, some of the problems are kind of, as your question suggests, kind of go back to sort of, the skew of the law schools, the skew of some of the state bars. As with almost any issue, I think there's going to be, it's once you recognize the problem, the solution is going to be multifaceted, and I think part of it is for some people, the right answer is engagement. it makes a huge difference to get just a couple of kind of, conservative faculty members at some of these law schools, what a difference that can make to the conservative students there and to the middle of the road students there, that, there are sort of differences. It's hard to sort of overstate the importance that kind of constructive engagement can have. So, Harvard Law School without, John Manning and Jack Goldsmith is a very different place than Harvard Law School with those people there and providing, sort of a role model for sort of students. So I think engagement is part of it, and I think sort of, writing off the big, top law schools or writing off the state bars and not trying to engage is a mistake. But at the same time, developing alternative institutions to sort of challenge them and provide market solutions. Easier to do that in the law school context, at least in theory, than in the, it's hard to have an alternative state bar. But I think that's also got to be sort of part of the thought process. And you see that, I think, with more with undergraduate. I mean, again, like institutions like Hillsdale or other sort of colleges that are kind of designedly, not like the others, is having a huge impact as well. And I think having that at the law school level would be a pretty powerful thing. And I know there's some nascent efforts to do it, but I don't think anybody's as far along at the law school level as they are at Hillsdale on the undergrad.
Other questions? We got 3 more hours. Oh, here.
Thank you.
His final question, and then we'll break.
Graham Peterson, I'm a 2L at Scalia Law. My impression of the nonprofits, you talked about boutiques and big law. My impression of the nonprofits is that on case intake, that the discretion you talked about the lawyers have to pick cases, that nonprofits want to pick sympathetic cases, the idea being that we can set new law and that unsympathetic clients will be defended in the long run. I'm not sure that's the case. It seems like by the time something's gotten bad enough that a sympathetic client has had their rights affected, that the unsympathetic guy already lost his rights a long time ago. I was wondering if you think that's true, if the nonprofits have a moral obligation to take unsympathetic clients and get back to like an ACLU, Nazis at Skokie kind of a world, or where you stand on all that, and if that's not happening, whether or not institutional reform with the nonprofits is possible, or if we need competitive institutions like yours to come in and pick up some of the slack.
Yeah, it's a great question. I also love the way you identify your law school. I'm every once in a while I get approached even by a young conservative student that tells me they go to George Mason Law School, and it just leaves me scratching my head. So thank you for that. Look, I think it's a great point. And I don't know that there's like an easy answer. And frankly, the people who are going to fall through sort of the cracks of the legal system, or certainly at the greatest danger of them, is going to be, the unpopular client who can't pay anybody to represent them, and yet they don't make, for particularly good sort of cause litigation. I think recognizing that that's going to be sort of a problem, I think is something that we should try to sort of deal with. But I do think it becomes very difficult, particularly once you get past the trial level. I mean, which is to say, you'd like to get, even somebody who's facing very unpopular circumstances and is not a good face for moving the law in the right direction. You'd like to get them sort of counsel and representation. But I'm not sure that it's going to be great for that person or other people in the long run if you then use them to sort of, make bad precedent that's going to govern sort of everybody's case. And so I guess what I would sort of say is, from the perspective of the nonprofits, I think, what I think their responsibility is sort of twofold. One, once they have a client, then they have a client. And so they can't sort of put the institutional interests ahead of the client. And you see that happen with some groups, left and right. And that's never sort of, a good dynamic. And I will say that in my own litigation, I often think that it's a huge advantage if I have like a institutional pro bono, like public interest litigant on the other side, because, you know, I feel like if they're not doing it right, they're going to put the institutional interests above their client's interest in a way that I can exploit on the other side. So I think once you take the client, you got to take the client and remember they're a client. But I also think you do have to sort of have in your sort of selection, do have to think like, okay, this is going to end well, or we're going to move the law, you know, forward in a good way if we, you know, if we take this case, especially if you're resource constrained and you can't take them all. And then I think what the best ones do, and I think some of the organizations, particularly in the religious liberty space on our side, are very good about this, is, you know, you don't just sort of take your client and then say, okay, well, that's the client, you know, he's terrible on TV, so let's keep him away from the TV cameras. I mean, you know, you work with them or you play up the most sympathetic aspects of the case, and you get yourself in a position like, you know, and, you know, okay, well, he's not going to be like good talking to the press, but, you know, his wife's great. So, you know, and you know, and I think you got to think in those terms to try to kind of maximize the representation you're giving the client, but at the same time, you know, advancing the institutional interest. But I mean, to be sure, I give advice to law students all the time, and one of the things I tell them is, if you can't get comfortable with the idea of representing clients under circumstances where you're actually, if you were a judge, would rule the other way, or, you know, that, you know, you're not fully aligned with your client all the time, like, you better go to a public interest firm, because, like, that's about the only way to get in a situation where you're always rooting for your clients, like, in your non-lawyer capacity. But that sort of solves that problem, but it doesn't solve the ethical problems that loom out there. And I do think, you know, there are some great organizations that do it exactly right. But I also think there's some organizations that, you know, sort of put the public interest as they define it above their client's interest, and you can't really do that and be faithful to the profession.
Well, again, thank you everyone in the audience for coming. Paul, this has been just terrific. Please join me in thanking our guest.